Aloha, everyone, and welcome to the County Committee on Planning. Today's order of business, we're at the Hilo, Hawaii County building. It's February 3rd, 2015, and it's 9:45 a.m. Please turn your cell phones, pagers, and other mobile communication devices on silent. I'll be calling this meeting to order. To my far left, we have Councilmember Margaret Willey, and we have Councilmember Aaron Chung, Councilmember Karen Eoff, Council Chair Drew Kinuha is on the Committee of Planning, Vice Chair of the Council, Councilmember Valerie Poindexter, Councilmember Danny Paleka, and Councilmember David Miley David. Sorry, I saw David right there. And of course, our County Clerk, Stuart Maeda. At this time, we're gonna take statements from the public on agenda items. Let us start. I know there's other testimonies out there, but let us just call up the testifiers here in Hilo. And Corey Harden is just on it, so she's right there. I know there's testifiers out there, but let's just take her testimony, and then we'll get on to the other testimony sites. Ms. Harden, could you please state your name and the item that you're testifying?
Yeah, good morning. Corey Harden, speaking in support of Bill 281 to revise the planned unit development, the PUD regulations. Speaking for myself, I'd like to thank Karen Eoff for introducing this bill. My only concern with the bill is the automatic approval if an application is not processed by the deadline, and I hope you'll consider changing this to automatic denial. We don't want bad projects to get through on technicalities. The PUD revisions are really needed. We almost lost a pristine native forest at Waikaku'u in Kona a few years ago because of a PUD. That forest is probably hundreds of years old, has one ohia over 100 feet tall. The understory has numerous native plants, and you can hear native birds chirp almost constantly in the treetops. The endangered eel, Hawaiian hawk, and Opeapea, the Hawaiian hoary bat, have been seen there. And kupuna from the area say there's many burials, but a PUD was approved that would have chopped down almost every tree. Waikaku'u was only saved because citizens went to great expense to hire a lawyer, and they put hours and hours into publicizing the issue and going to various county meetings. And finally, a judge found that the county had failed in its duty to protect natural resources and had violated the Kona Community Development Plan. Other PUDs, also approved the same way by the Planning Director and Board of Appeals, were recently overturned in court. Bill 281 provides badly needed protections for our land and increases public involvement. The bill allows contested case proceedings, requires public hearings, requires approval by the Planning Commission, not just one person, the Planning Director, requires compliance with community development plans, allows 150 days to consider a PUD versus the current 60 days. It changes appeals from the Board of Appeals to Third Circuit Court, and it does not allow partial approvals. So please support this bill. Thank you.
Thank you, Ms. Harden. Good morning, Kona. I see that you have two testifiers. Scott, is that you?
Yeah. Good morning, Chair. We have 6 total over here in Kona today. Our first 2 testifiers is Sydney Sheree in support of Bill 281, and our second testifier is Osun Abanyega in support of Bill 281.
Scott, could you start with Mr. Sheree?
Thank you very much, council members, for your attention. My name is Sidney Sherray. I live here in Kona at Ohio States, and I'm speaking on behalf of the membership of Ohio States as well. I'm speaking in favor of Bill 281, and I speak in favor of it based upon some personal history, having been a governmental commission member in various instances. I find that the ability of the public to address issues before a commission affords the greatest opportunity for the democratic process to, in fact, prevail. And I would strongly suggest that opportunity be given to the residents here in Hawaii as well in support of 281. Thank you so much.
Thank you.
Okay, go ahead.
My name is Adeboyega Osun, and on behalf of myself, my wife, and the Kona Orchard Homeowners Association, of which I'm president, I strongly support Bill 281 because it provides needed transparency to taxpayers. Thank you.
Thank you, Mr. Osun. Moving on to the other testimony sites. Let's see, who do we have? Let's go with Kau. Good morning, Kau. Is there any testifiers there?
Good morning, Mr. Chair. We have no testifiers for your committee today. Thank you.
Thank you. Now moving on to Kohala. Is there any testifiers?
Aloha, Chair. I have no testifiers for your committee today.
Thank you. Good morning, Waimea. Do you have any testifiers?
Good morning, Chair. We currently have one testifier with a possible second testifier en route.
Okay, we'll go with your first testimony and we'll come back to you when we are done with the other testimony sites.
Okay, our first testifier is Phyllis Tarell, representing herself, speaking on Bill 281 in support.
Good morning. My name is Phyllis Tarell. I live here in Waimea. My husband, Joel Cohen, has provided written testimony in support of Bill 281, and I'm here also in support. This bill provides a long-term public policy, which is badly needed in our county. It defines the role of staff through review and analysis, which can then be understood by all the decision makers. It also provides notification to surrounding communities affected by the communications, a notification to the surrounding committees that are affected by these PUD applications. That allows the public to provide necessary and very important input. One of the other key issues is public trust in government. We know that there have been really great difficulties with the trust of the federal government. The state have been issues, and we want the county, people here in the county to feel like they can trust what our governmental entities are doing. The process that's contained in this bill will work, and I strongly support approval of this bill. Thank you.
Thank you, ma'am. If you need more extra time, I know the telephone went off in the middle of your testimony.
Oh, it just confused me a little bit. I think that basically those are the key issues that I wanted to address. I hope you've had a chance to read my husband Joel Cohen's written testimony. He was hoping to get here, but he had a 9 o'clock meeting elsewhere and apparently is still involved in that. Thank you.
Thank you. Moving on to the next testimony site, we have Pahoa. Good morning, Mike. Do we have any testifiers?
Good morning, Chair. No, we do not have any testifiers for your committee this morning.
Okay. Do we have any? Did I miss any other sites? Okay. I'll take that silence as a no. Moving back to Waimea, Dave is our second testifier.
Good morning, Chair. No, he has not arrived.
Okay. I just want to let everybody know that we received written testimony, and we are now. I'm going to close the. Oh, What a surprise. Okay. I'm so sorry, Scott. How many testifiers do you have in Kona?
We have 5 more testifiers here.
Perfect. I'll pay more attention to that, and I won't miss it next time. Scott, could you start on with the first 2 testimonies?
Okay, our next 2 testifiers, we have Tricia Van Every in support of 281. Also, we have Lekeke Bumenglag in support of 281. Go ahead, Patricia.
I am Tricia Van Every. I am in favor of this bill because it gives taxpaying citizens the transparency we need and entitled to. Therefore, I do support Bill 281.
Aloha kakahiaka. My name is Lekeke Bumenglag, a homeowner and president of the Pualani Estates at Kona Homeowners Association, a community of over 360 homeowners. I am here to voice my support to bring transparency and the collective mana'o, the input of all citizens. As homeowners and taxpayers, we are entitled to have a greater voice on proposed real estate developments on our island. Bill 281 is a positive step in that direction, and therefore I am in favor of supporting Bill 281. Mahalo nui loa.
Okay, Scott, if you can proceed.
You won't.
Thank you, Chair. 1 second. Matt and Tom Madsen. Next 2 testifiers, we have Tom Madsen in support of 281 and Mac McGinnis in support of 281. Go ahead, Tom.
Good morning. I'm Tom Madsen and president of the Homeowners Association Hualalai Colony, and I am here to support Bill number 281, which is would allow for community input to any PUD approval process and would remove any lack of transparency by the Council and Planning Department.
My name is Matt McGinnis. My wife and I reside in Kona Orchard Subdivision in Kona. Good morning, Mr. Chairman, ladies and gentlemen. I'm here to speak today in favor of Bill 281 on my behalf, on my wife's behalf, and my neighborhood association's behalf as the vice president of the Kona Orchards Homeowners Association. Residents, citizens in my neighborhood have been concerned about issues regarding the PUD approval process. Your passage of this bill will positively demonstrate the county's willingness to give the citizens the transparency to which they are entitled. Thank you for your consideration and thank you for your time.
Thank you, gentlemen.
Yeah, our last testifier today, Joel Cooperson, in support of Bill 281.
Okay. Aloha. My name is Joel Cooperson, longtime resident in Kona, going on 46 years, taught in the community public school in this community for 31 and a half years, 7th and 8th graders primarily. I'm president of the Homeowners Association at Heights at Hualalai, and we are in total support of Bill 281 because, and it's been said many times already today, that transparency equals trust in government, and open government, it doesn't get better than that. Mahalo.
Thank you. All right. Thank you, Scott. I just want to check all the testimony sites. Are there any testifiers that I've missed? Okay, I'm going to take that silence as a no. At this time, we're going to close the testimonies and moving on to communications. Looks like we have no communications. So order of resolutions. Clerk, Mr. Clerk, could you please read Resolution 41-15?
Order of Resolutions. Resolution 41-15 authorizes approval of in lieu fair share contribution to satisfy condition M of ordinance number 09-149. Authorizes the reimbursement of $2,400, the cost of contributing a 15-foot wide future road widening strip along the property frontage of Inaola Drive to offset future fair share contributions. Reference Communication 65, introduced by Mr. Iligan by request.
May I have a motion to approve Resolution 41-15?
So, second.
Moved by Councilmember Miley David and second by Councilmember Danny Paleka. Moving on to discussions. Does any council member at this time? No discussion. May I have a voice vote? All in favor say aye. Any opposed? None at this time. We have a 9 unanimous vote. Resolution 41-15 is moved to council with a positive recommendation. Moving on to bills of ordinance. Mr. Clerk, could you please read Bill 281?
Bills for ordinances. Bill 281, 2012-2014, amends Chapter 25, Article 6, Division 1, and Article 5 of the Hawaii County Code 1983, 2005 edition as amended, relating to planned unit development. Amends the zoning code to require planned unit development, PUD, applications to be reviewed and acted on by either the Leeward or Windward Planning Commission to be determined based on the location of the property for which the PUD is sought. Reference Communication 1025, introduced by Ms. Eoff, referred to the Planning Director and Planning Commission's September 16, 2014. Communication 70 from Mayor William P. Kanoy, dated January 7, 2015, transmitting the Windward Planning Commission's favorable recommendation with reservations and the Leeward Planning Commission's favorable recommendation with qualifications.
May I have a motion to approve Bill 281 and all related communications?
So moved.
Second.
Moved by Councilmember Margaret Willie and seconded by Councilmember Karen Eoff. Any discussion? All right, same time. I'm going to go with my favorite council member, Karen Eoff.
Thank you, Mr. Chair. Well, I introduced this bill last term, and I worked on it because I really have been a strong proponent of citizens' participation in the planning process. That's kind of was my introduction to politics many years ago. So during the last term, we did discuss 2 bills that related to plan unit developments. One was a carryover from the term before that. It was Bill 291, and the other one was Bill 59. Both of those were discussed in Planning Committee, but found to have problems or negative recommendations from the Planning Commission. So I think we just postponed those 2 bills. In the meantime, I wanted to look at something that would work for plan unit developments, and the idea was discussed. I worked with some planning department and my staff, and we came up with this Bill 281, which would change the process for approving plan unit development from solely under the discretion of the planning director, and rather than that, it would go before the Planning Commission, which would offer the transparency that many of the testifiers spoke about. PUDs do ask for exceptions from the zoning code, and so I looked at the special permit process that we already have in the planning department, and this bill pretty much follows the same process as special permits. So I also, as Ms. Harden stated, did have a concern about the automatic approval part of the bill and questioned planning staff about that because that was kind of a concern. But I now understand that that is required by state law, and I think I could ask Mr. Bronte and Mr. Director Kinuha to come up and further explain that part, if they don't mind.
Come on, gentlemen. I guess you lost.
So, and I just want to state before Mr. Bronte introduces himself that another important part of this bill is the requirement that the applications be compatible with the surrounding community and conform to the applicable CDPs, which I thought was an important addition. So, Mr. Bronte, if you would address the automatic approval part.
Good morning, Committee Chair and fellow committee members. William Bronte, Deputy Corporation Counsel. Ms. Councilwoman Eoff's rendition of the facts and our involvement with this proposal is pretty accurate. And, you know, there was some discussion. The initial draft of this amendment that came to our office was language that incorporated an automatic denial if the time limit had, you know, passed, and there was no specific recommendation from the planning committee or the planning director regarding the application. And, you know, what happened in 2008 was there was an amendment proposed by the governor, an amendment to the HRS, and specifically section, or chapter 91, section 13.5. And now, you know, the HRS codifies specific language that, you know, indicates that if a business application or a development comes forward and, you know, there's a deadline associated with that application for, you know, action to be taken. And if no action is taken within that period of time, there is language that the application shall be deemed as approved. And, you know, it was that language that formulated the basis for my opinion to Councilwoman Eoff regarding, you know, further amending her proposed legislation to reflect that. So that's how we got to that stage.
Thank you. Yeah, and I also spoke and thought it through after realizing that we had to change it. And I believe that, how does the law state? But if there's been some input from the public regarding the particular application, then it wouldn't be able to be automatically approved if there was concerns expressed prior.
Correct. Right? There is some exceptions within that regulation that if the process is ongoing, if the parties agree to extension of time, which generally is the case. You know, it's been my experience that when these particular applications come forward, you know, the applicant is pretty amenable to, you know, any requests for continuances on behalf of the county, you know, because, you know, the whole emphasis and the whole basis for, you know, the application process is to ensure that the process is handled correctly. You know, all the procedures are followed correctly. And, you know, nobody's trying to hoodwink anybody or sneak something through. At least it hasn't been my experience. You know, the applicants have been forthcoming. They've been, you know, real upfront, you know, historically. And, you know, pretty much, you know, they're dealing with the planning department. And I think, you know, there's a good relationship between the applicants and the planning department personnel.
Thank you. And just, I'll yield in a minute, but I just wanted to thank you for your help and urge my fellow council members to support this bill. I think it's timely. I spoke to a lot of attorneys also who have been involved in some of the challenges to PUDs that have been problematic over the last several years. And from all different angles, I've been told that this is a good time to enact this change. So I'll yield.
Well done, Councilmember Eoff.
Thank you.
Credit goes to you. Councilmember Willie?
Yeah. Thank you. I think the key here is what one of the speakers, testifiers, said is collective manao, is really getting in people that are in the area and getting input from them. In my opinion, there have been several disaster PUDs in Waimea area, including allowing exceptions that just make no sense and are now a safety, what I consider quite an extreme safety consideration, where this is the example I'm thinking of is on Lindsay Road, across from the park, and it's Parkview PUD, and that was approved. Every single, I think, tree was cut down, but they allowed it to be like within, the fence is like within 6 feet of the pavement, and on the other side is where the house on the other side goes right up to the edge of or their property goes up to the edge of the road, and there you have all of the Parker School development in there. So it's a huge mess. It's very unsafe. And if they had just said, no, you don't get an exception from putting a sidewalk in here, life would be much safer in Waimea. I could go on with examples, but I think that if there had been more input or opportunity for the public, I think that kind of thing would not have happened. And also just underlining the point about transparency and trust in the government. I think it's important to point out that previously, I think it was prior to 2010, or I forget which year the charter amendment went in, there was opportunity for hearings, so we're not really doing something new. And when I looked into this, which is a number of years ago, at that time I think we were one of only 3 states that would allow something like a PUD to go through where there was no requirement of public input. Just moving on to the specifics here, I wanted to just bring up a couple things. I do want to underline the part, appreciate that the applicable community development plan and that's in there. I'm very concerned. I don't, even now we have that Missler case basically, in my view, attacking the Kona CDP, but that we stress that we don't have towns and villages, and the community development plan are very important in a way that the action committees to bridge the people to the first layer of government on the county level. I do would like to see that one additional copy is provided and that it be done in a online submission so that the members of any of the CDP committee could get a copy easily. Right now, say in North Kohala, if they wanted to look at this, or South Kohala, they would have to go to Kona or Hilo to go look at it and see if that was something that's of interest. So I would like there to be a requirement for a submission online. I do have 2 quick questions, if either Mr. Bronte or Kinuha could come forward. Okay.
Good morning, Mr. Chairman, members of the Planning Committee, Dwayne Kinuha, Planning Director.
Okay, in section 25.5.8, it talks about exceptions that may be approved by the commission with a planned unit development or by the director within a cluster plan development. And if you could just remind me, what is the difference? What is a cluster plan development versus a planned unit development, and why would that distinction? Why do we have that kind of distinction? Should cluster plan developments also be going to the planning commission, or do they? Or it's under E. I see that. 25.5.8, 25.5.8, other regulations, and it just distinguishes between, on page 6, sort of middle of the page. Makes a distinction between a planned unit development and a cluster plan development. 255A-E.
Okay. And your question was?
Okay. So it differentiates between a planned unit development and the handling of a cluster plan development. So preliminary question, just if you could remind me, what is the difference between those and why there would be a distinction, or should cluster plan developments go?
Councilmember Willie, please finish up your train of thought and get this question answered, and then we'll move on to the next council member. Thank you.
Okay. The reason for the change there is currently both the cluster plan development, which is a separate component of the zoning code, that applies to primarily residential zone properties, is that both the cluster, in the current ordinance, both the cluster plan and the PUD were handled administratively. So now that the PUD is being transferred to the commission, that's why this change was there. So the commission does the PUD, but the cluster plan still retains, is still done within the department.
Okay, but what is a cluster plan? How does that differentiate from a planned unit development?
It's basically the same component, except it only applies to residential.
And that's your last question?
Yeah.
Councilmember Willie?
Just on that distinction, shouldn't we include cluster plan development and have that be considered by the Planning Commission as well? I just don't understand why we don't include that as well. Look over to Karen, you're telling me?
It was Council Chairman Eoff's initiative, it wasn't ours.
Okay, I'll follow up after.
Mm-hmm.
Thank you. Councilmember Miley David?
Yes, hi. Good morning, Director.
Morning.
I really don't have a question for you except just to state my support for this bill and the efforts that your department and Ms. Eoff has made. I do want to just note that over the past 30 years, I've been very involved, as Ms. Eoff has been, in land use. And as much as I support the transparency, my view of this bill, for me, is more or less on the basis that as we grow as an island community, the director approved process may have worked 30 years ago, but as we grow, I see this as an involvement, and this is the appropriate time to bring forth a change like this, because we have more development and we have more community input. So I think the timing is right. It's no reflection on the department as far as it being a jurisdictional, the director approved. I think it's the process as we grow as an island community that makes this type of legislation meaningful. So thank you, Councilmember Eoff. I support this. Mahalo.
Thank you for that. And in the during the commission proceedings, I also, it's not in the background itself, but I also provided some historical perspective that your statement is actually back to the future, because back in the early 70s, the PUD was issued by the Planning Commission. All right, and the Charter Commission, and I believe it was in the late 70s or early 80s, reverted that responsibility back to the department. So it's actually, it's full circle now.
All right, still our first round. Did Councilmember Drew Kinuha?
Thank you. I fully support this. I know this has been going on, especially the whole last term with the last council, and thank you, Ms. Eoff, for working on this. A lot of issues were fine-tuned, I guess, to make it so that we can have that transparency, the community can see and have that voice, which is necessary, especially in the democratic process. So I'm glad for that, and this bill actually does that. With regards to what you're saying about the Charter Commission reverting it back to the director, is this going to have any effect on the actual charter? Putting this back to the commission, I mean, not effect on the charter, but is this in violation of the charter if we're putting it to the commission when it was changed to when it was first put for the planning director?
Yeah, okay. The reason what started that change was the planning commission at that time also issued all variances. So every variance was issued by the planning commission. And there was it was just so much work for the commission that the Charter Commission in their review looked at that and made a determination that that was more an administrative function. The variance process is more administrative function. The PUD process was viewed as a form of a variance. Okay, so that's why it also got reverted back to that. So in this particular version of the bill, Councilperson Eoff and myself and Corporation Counsel Bronte, we took a look at that issue, quite closely, and that being the case, you'll see no references to variances in this particular bill. It's exceptions, and it actually functions as that. It's actually not one big variance. It's a site development component. The keys, again, the basic fundamentals of a PUD is you can't get more density than you already have. It doesn't give you any more density than you already have. And you can't have a use that's not already permitted. Okay, so with those are the two fundamentals of a PUD. Within that context, then there's the PUD allows you for a variety of setbacks, building heights, roadway width adjustments, and I think let's put it this way: since 2012 to today, administratively, we only processed 7 PUDs. It's not as if they're coming in by the truckloads. Okay, but I think the trend, especially it looked like there were a lot of PUD applications in 2012, has probably occurred or was probably occurring because in the land development arena, most of the easily developmental properties are already developed. Okay, so what you have left are the properties that are currently zoned but have a little bit more difficult situations in terms of topography and access and things like that, which is why they may, there was probably more of the use of the PUD for those kinds of properties, over that period of time. But again, it's not as if there were tons of these things going through that were being administratively processed. So from that standpoint, we don't believe that the increased transparency through a planning commission hearing is going to necessarily be a deterrent, okay, to people coming in for PUDs. If it's going to work, it's going to, that may be the only way for things to work. Otherwise, what you have is, you'll have projects that may end up being just your cookie cutter projects. If not for the ability to provide some flexibility for lot layouts, lot sizes, street adjustments, things of that sort.
Okay, thank you. Just really quickly, I know one of the commissioners had a reservation, because one of the questions I had was, does the commission have the capability, the education background to make some of these decisions? And one commissioner actually asked that, the commission's decision making, that it's a heavy burden. He sensed that it is a heavy burden and they're uncomfortable with making certain recommendations only because they'd have difficulty understanding all of the legalities and all the issues surrounding these PUDs. And I know you have corporation counsel there and of course yourself and the deputy director, but that's just the question I had, reverting back to the planning commission. Do they have, I like that it's going to the planning commission. I know they're fully capable, but a lot of times these commissions have problems with quorum, and a lot of these issues kind of go by. And with the I think it's 60 days for approval, that a lot of them might actually get automatically approved because the lack of quorum, and they can't meet in front of the commission. So that's kind of the issue. Not really an issue, but it's there, it's present. Everybody will know about it, but. Based off of this commissioner and his saying that this could be the heavy burden and the difficulty in understanding that, is that a issue that, obviously we're going to have to face, or the commission is going to have to face?
Again, if there were PUD applications lined up, where they'd be having 2 or 3 of them every meeting, possibly, but the record just doesn't bear out that there's a whole lot of these. The commission also hears and determines use permits and special permits and special management area use permits, which in their own regard are somewhat technical and complicated from a same perspective too. So,
okay, thank you. I fully support this bill and urge the rest of the council to support as well. Thank you, Mr. Chair.
Thank you. So it's still the first round. Is there any council member who hasn't spoken? Since there are none at this time, Council Member Willie.
Thank you. When we talk about that this is variances, are these simply variances from the subdivision code, or how does this interact with zoning? Is it somehow, if something's coming forward and needs of zoning change? I'm just not sure. Are we only dealing with variances from the subdivision code? Because I think you said about otherwise you end up with a cookie cutter like 5-acre ag or something.
No, I'll give you, some examples are like the Hilton Waikoloa. They got a PUD for a height exception, say, for example. So it's not only the subdivision code, it's some variances from the zoning code as well. If you go down Kauai High Road just before you make the turn onto Kuinka Ahumano Highway, that project on the right side there, that was one of the very, very old PUDs, and that project basically was a zero lot line project.
A zero what?
Lot line, zero lot line. So basically you had 2 lots and you have those single family residences like built. There's no side yard setback, let's put it that way. But that was a PUD application back in those days. So it's primarily setback from the zoning. It's exceptions from the zoning code and the subdivision code. It's a combination depending upon what the site and situation is. Again, the clarification is that you can't use a PUD to rezone, right? And you can't use a PUD to introduce a use that's not already permitted by the zone you have, yeah.
Okay, but what now if there's a zoning change that would come to the council?
Correct. Yep.
So if in that instance where we have the jurisdiction to approve those changes, how does that, I'm just trying to see how they interact. So someone comes forward for some, their PUD for an exception to the zoning, and you all, the planning commission says okay, then it's coming after that to us to decide if we could affirm that change?
No, it's not an exception to the zoning. How should I explain it? It's, again, you can't, if you have a project that's zoned for residential and the total project can only have X number of units out of there, okay? The PUD allows you to mix and match within that zone and within that density. So in other words, you couldn't do a mix and match and get more units, through that the zoning
density
allows. Yeah, the density, you can't get more units.
Maybe, Bill, can you come up? And Bill, you understand what I'm getting at? Are there, though, exceptions in terms of zoning restrictions? I'm not talking density and that, where it would then be something that we as a council would have jurisdiction over.
No, I'm not completely sure. Again, I'm sorry. I'm Deputy Corporation Counsel William Bronte. I'm not completely sure if we totally understand the question. I think from what I do gather is what the planning director is indicating is that a PUD application and a request under the PUD doesn't afford the applicant to have any greater use of the property as it relates to the zoning requirements. So if there's a zoning requirement on a particular parcel, what Director Kinuha is saying is that you can't use the property in a manner that it isn't specifically zoned for. So a residentially zoned property will still have to comply with the requirements of the residential zone, the zoning requirements. Further, I think what the point we're trying to make is that if a parcel has a specific density, say a parcel is zoned as Ag 10 and it's a 100-acre parcel, that affords the property owner at that current zoning 10 lots, right? The potential for 10 lots. So when the PUD application comes in, no matter what the configuration is within that 100 acres, the applicant will still only get 10 lots, whether it be, 10,000 square foot lots or 5 10,000 square foot lots, and here do the math here, and 5, so that doesn't get changed, and then the remaining portion will most often stay as open space. But I think the one exemption that's specifically addressed in this proposal is section 25.6.11, where it relates to the height exemption authorized, and that's a specific requirement. That's a zoning requirement, under and it says the building approval on the PUD permit may exceed the height limit specified under the zoning district of the property. So that's a specific item that is related to zoning that this PUD, a PUD applicant may request that his application not be subject to that height requirement.
Okay, so I understand, Ruth, regard to use and density, that there aren't changes there, so it doesn't interfere with zoning in that respect. So I was looking at more like what you're talking about, height. When someone comes in here with a zoning question, here we want to do this, and here are requirements, and this is in this zone, has following requirements, whether it's height or otherwise. Then let's say the Planning Commission says, yes, we're giving that, we agree with that exemption. It's really getting into an exception to something that we would ordinarily, that someone's coming forward with a zoning change.
Historically, it's been my position that when a proposed amendment, whether it be a proposal from the Planning Commission or whether it be a proposal from the applicant, relates to a specific condition under the zoning, which was passed by ordinance, the opinion from our office has always been any amendments to those specific zoning conditions have to go through County Council.
Okay, that's what I wanted to hear. Okay, that was my and then let me just ask you in terms of the last question, the community development plans. What is the your corporation council's current sort of the applying the applicability of the community development plans? Would you uphold this?
Again, I don't want to speak. I'll let the director respond to that answer. But legally, there's a requirement as these applications come forward, the requirement that the office use, which is the requirement which we see across the board, which is analogous to the process in a special permit, is that the application has to be consistent with first the general plan, and now there's the secondary language that they have to be in compliance with the community development plans as well. Mm-hmm. So that process is not going to get subverted in any way.
So I think I'm going a little afield because I'm really looking for whether you're challenging that in the Missler case and that legality. So I'll yield there, but with concern.
Thank you for your concern, Councilmember Willie. At this time, if you council members bear with me, we are 7 minutes over our time. I believe the Committee of Public Safety and Mass Transit is supposed to start at 10:30. May I ask the chair of that committee if it's okay if we could just finish up this committee and move on and adjourn and then continue to yours?
Objection.
Thank you so much. All right, moving on. Is there any other council members who wish to speak? Doesn't look like none at this time. We're going to do a voice vote. All in favor say aye.
Aye.
Any opposed? We have a unanimous vote on the bill 281, and we'll move to council with a positive recommendation. Moving on to Bill 17. Mr. Clerk, could you please read that?
Bill 17 amends Section 25-8-33 City of Hilo Zone Map, Article 8, Chapter 25 Zoning Code of the Hawaii County Code 1983, 2005 edition by changing the district classification from agricultural 3 acres A-3A to family agricultural 1 acre FA-1A at Waiakea Homesteads, Second Series, Waiakea, South Hilo, Hawaii, covered by Tax Map Key 2-4-034:045. Applicants Melvin and Brenda Morris. Area approximately 3.002 acres. The Windward Planning Commission forwards its favorable recommendation for the change of zone, which would allow the applicants to subdivide the property into 3 lots to be conveyed to the applicant's children. Reference Communication 63, introduced by Mr. Iligan by request.
May I have a motion to approve Bill 17?
So moved.
Moved by Councilmember Paleka, seconded by Councilmember Dennis Fresh-Onishi. Any discussion? Looks like none at this time. I'm going to do a voice vote. All in favor say aye. Aye. Any opposed? None. It's a unanimous approval. Bill 17 will move to council with a positive recommendation. Moving on to Bill 18. Mr. Clerk, could you please read that?
Bill 18 amends Section 25-8-3 North Kona District Zone Map, Article 8, Chapter 25 Zoning Code of the Hawaii County Code 1983, 2005 edition by changing the district classification from agricultural 1 acre A1A to village commercial 10,000 square feet CV-10 at Holualoa, North Kona, Hawaii, covered by Tax Map Key 7-6-013:017. Applicant Orchid Isle Auto Center. Area 1.002 acre. The Leeward Planning Commission forwards its favorable recommendation for this change of zone, which would allow the applicant to develop automobile storage and employee parking. Reference Communication 64, introduced by Mr. Iligan by request.
May I have a motion to approve Bill 18? Moved by Councilmember Kinuha, seconded by Councilmember Poindexter. Any discussion? Councilmember Kinuha?
Thank you, Mr. Chair. I just wanted to say I support this Bill 18. I did go to the Planning Commission meeting, and there were some concerns by several residents. But what came out of the meeting was a really good thing. I think the applicant really listened to the community and added in E and F, which Walua Road shall not be used as a vehicular access to the project site. And also, as agreed upon by the applicant, all structures on the project site shall be limited to 1 story and a maximum of 20 feet in height. And I really appreciate that. The community seemed pretty positive about working with them. So I just want to thank you guys for working with them. And that was just a few of the concerns. I know the rezoning is important for that area, especially to get the cars off of the side of the road, Laco Street. And I know I had an issue about paving that area before it was rezoned, but I think you explained perfectly within the Planning Commission meeting notes. Everybody can take a look at that, about why it was necessary to do so and to convert this from ag to village commercial. So I just want to thank the applicant, urge everybody else's support. I think it's a good thing for this area. It's within the general plan. What's it called? It's within the applicable use of the general plan. So ask everybody to support this, and no further discussion for myself. I'll yield.
Thank you for working with the community, and your cooperation is much appreciated. Any other council members? Looks like none at this time. We're going to do a voice vote. All in favor say aye. Aye. Any opposed? Unanimous approval. Moving Bill 18. Bill 18 moves to council with a positive recommendation. At this time, thank you. Councilmember Kinuha has moved to adjourn. Seconded by Councilmember Poindexter. All in favor say aye. Aye. Any opposed? Unanimous vote to adjourn. It seems like you guys want to get out of here and close me out as soon as possible. Okay, thank you. And now we are adjourned.